Today, we are talking about patent new rules and laws in China. And in case you do not know the overview of patent law system, I will firstly introduce patent basics in China. And following that, it's the focus of today. It's the strategy recommendation before the registration and after the registration. It covers a long period and hopefully the whole lifetime of your patent cycle. And lastly, I will leave some takeaway messages. For patent types in China, it's a little bit different from Europe. That means the biggest difference is the design patents. So there are three types of patents in China: invention patent, utility models, and design patents, which protects the industrial design. And if you see what to protect of these three patents, we will see a very obvious difference. First one, the invention patent protects the new technical solution or process. It protects the function of the new products or the new invention. And utility model, it protects the shape or structural features of the invention. It protects the function. But industrial design, as many of you may know, it does not protect the function of the invention. It only protects the aesthetic aspects of the products. Sometimes you will find the design can be included in utility models as well as industrial design, because those two patents protect different parts of the products. And in terms of how long you can expect to get the protection, invention patent takes the longest. Usually in China, it takes from 2 to 6 years to register, because it goes through the substantive examination. That means the China Intellectual Property Administration, the IP office, CNIPA, they will go through the application and look at the detail and cross-check and do all the comprehensive examination before they approve the patent application. Different from that, for utility models and design patents, there is no substantive examination. The CNIPA simply check the formality of formality of your application. Therefore, it takes less than a year to register. And the protection terms for the invention patent, it's also the longest, while the time to get it protected is longest, it's 20 years. And utility model is the shortest, 10 years, and industrial design is 15 years. And just here is a very simple example for you to understand what's the difference between those three types of patent. So if your company has storage battery, it's different from the prior storage battery, because you invented this new management system that allows the battery to work more efficiently and last longer. Therefore, it is a new solution. And for that new solution, you can consider to use invention patents to apply for invention patent. And after the approval, you will enjoy 20 years of protection. And if your battery has new design of structure, it can reduce the temperature when the user's using it. That we will conclude it as a functional invention because of the design, because of the structure. Then you can use utility models to protect that. And for the unique shape or design of the battery, not protecting the function, you can consider the industrial design. Hopefully, it's clear for you to understand those three types of patent. And now we know what kind of patents in China, and then we should understand there is some important principles for you to consider what time and how to protect patent in China. First to file principle applies here. That means if you are not the first to file your patent in China, someone else did it, and the persons who filed before you eventually get the patent in China, then they can claim they are the patent owner. It's possible to clear such patent if they are bad faith, or you have if you can provide the owner is bad faith, it's possible. However, that will take a long time, and you have to you have to spend a lot of money to do so. So if you have patent and you plan to use that in China, you should consider to file your patent application as soon as possible. And second principle is patent rights is territory right. That means if you have European patent or if you have European patent, that doesn't mean you have patent right in China. You still need to go through an independent procedure. And without the registration of your patent, you cannot fully enforce your rights. That means someone infringe your patent, copy your invention in China. You can only take enforcement actions after your patent is registered. The last principle is very important, that will decide what time you should consider to file your patent in China. So if your patent has been public anywhere in China, not only in China, but also the other markets, including Europe and US, any other market around the world, you may already lose the absolute novelty of your invention. That means you cannot patent your invention anymore. But there are certain exemptions of this absolute novelty. That means if you satisfy any of these 4 criteria, within 6 months of the disclosure of your invention, you can still consider applying for registration of your patent, your invention in China. The first is if you disclose your invention during an international trade fairs sponsored or recognized by the Chinese government. For example, like the China International Import Expo in Shanghai. In that case, you can still file your patent application within 6 months. Of course, you need to supplement the evidence to prove that you attend this international trade fair. And the second one is you disclose the invention during an academic or technological conference. And this is not any conference. There are certain criteria we will cover later. Basically, it's organized by an international organization, but this international organization has to be recognized by the Chinese authority. And if your invention is disclosed for public interest, or someone leaked your invention without your consent, for those situations, you can still enjoy the absolute novelty. That means patent application is still possible within 6 months. So the timing is very important. And today we are going to see the new patent laws and rules. And what are those? I'm not going to go through the very details of the articles, but here you should know there are 3 major law and rules of patent. The first is the patent law, which is amended in 2021. That is the 4th amendment of patent law in history. The second one is the implementing regulations of the patent law as well. And the third one is the patent examination guideline. The last 2 only enter into force earlier this year. And I believe a lot of the participants are from Europe. So for your easier understanding of the Chinese patent system, I made a comparison of IP systems in Europe and China. So if you see the common, you can see that patents, including the invention patent and utility models, as well as the industrial designs, can be extended to China and in Europe internationally. So for invention patent and utility models, you can consider to use PCT, the international system, to extend to China. And for industrial design, you can use the Hague system to extend to China. For industrial design international rules, it's only available 2 years ago. It's still quite a new solution. And we encourage the European SMEs, EU SMEs, to use this system to discover it, and it could save your cost, and it could also save your time to do that. But we will discuss about it later in details. And invention patent protection terms, both systems last 20 years. And if you see the difference, there are more for enforcement in Europe, and it's possible to enforce without registration. However, in mainland China, you have to register your IP before you take the full enforcement action. And invention patents takes shorter time in Europe to get compared with in China. It takes 2 to 6 years to register. And also software can be patented in China. That's not very common in Europe. For industrial design in Europe, you can choose to register it or not to register it. If you choose not register it, you can get the protection for 3 years. If you register it, it will get the longer protection term for 25 years. And in China, you have to register industrial design because it's part of the patent system. And the protection term is shorter than in Europe. It's 15 years. And utility model has been widely used in China. However, for Europe, it's not as common. And I already mentioned that patent software can be patented in China. That may bring some of the company's interest if you are in the software development industry or your products actually includes your the software you developed. So for a patent for your software to be patentable, it should be to solve a technical problem, use technical means, and achieve a technical result. And I know it's a little bit abstract, but I list 4 of the examples of the patentable software, and it might be easier for you to understand what what software you can consider to patent in China. First is computer program for industrial process. And for this one, just give you an example. If you have a method of controlling a rubber molding process using a computer program, and afterwards it can enhance the quality of the products greatly, you can see that this solved a technical problem and achieve a technical result by enhancing the quality of the products. For this situation, you can consider to patent your computer programs because it brings the new solution for industrial process. And the second software you can consider to patent it is the software to improve the internal performance of computer. If you have a solution which can expand the storage capacity of the computers or smartphone using a virtual device file system, you can consider to patent that kind of software because it has the goal to improve the internal performance of computers. And the third type is the software to control, measure, and test process. An example is that if you use the computer program to analyze the signals collected by the sensors and measure the viscosity of the liquids in a more accurately and quickly manner, then you can consider to patent that software. The last one is the software to process external data. If you have a software that can remove the image noise and achieve a higher resolution for the image by inputting the pixel data of the image in the software, for that software, it could be regarded as process external data. In that case, you can consider patent that. However, patent a software is complicated, and you definitely need a patent attorney who understands the Chinese law and who has experience dealing with similar case in China. And before the registration, another consideration you should take is when you protect your industrial design and using the international system to extend to China. As I already mentioned, 2 years ago, international system, Hague system, is available in China. That's great news for the industrial design owner because there's another possibility, another option you can consider to protect your industrial design. But you need to keep in mind that even though it's international design, it is still each national or regional IP office to make the decision, the final decision, whether to grant the industrial design rights or not. So the requirements for design filing is different from country to country. And for China, there are certain very specific requirements. And I didn't expect all the businessman or the industrial design owner has to remember all the details very well after our webinar. But what you should keep in mind is that if you use the international design, you should still check what is the specific requirement in China, and to make sure when you file the international application or registration, you already satisfy those requirements, or you should discuss with the patent attorney when you decide to extend your international design to China. And here are the three very common situations that in practice when you use international design system in China. That means these are the three common issues, common problems, common mistakes the European SMEs will make. The first is lack of brief description. What's brief description? It is a statement that it's the statement about the design of your industrial design, and that should include the shape, pattern, color, or the combination of those three elements. And for Europe, for EU, this brief description is optional. You can choose not to file it, but in China, it's mandatory. That means you have to file this brief description when you file the international registration and extend to China. If you fail to do so, the CNIPA, the examining office in China, they will issue an office actions. That means they will refuse your registration. But you can hire a patent attorney and file a brief description as supplement later on. You can overcome this office action. And the second mistake is lack of unity of design. What's unity of design? That unity of design is that means the designs share the same characteristics, like the three elements we mentioned, the shape, pattern, and color, and produce the same general impression. This is very general ideas of unity design, and sometimes in different countries, the examiners will have different criteria again. Generally, it's ideal that in one application, you only include one design, because that's a restriction. It's a strict definition of unity of design. But you can still file up to 10 designs if those 10 designs are for the same products, or for the products that are sold or used in sets. That will still satisfy the unity of design in China. In Europe, that will be 100 designs. You can see it's quite a difference between 10 and 11 designs. If you fail to do so, for example, you file 100 designs in one application, but obviously that doesn't satisfy Chinese requirement, then you can still make it right by filing a divisional of application, meaning separating your design to a different application. And the last problem, the last common mistake, it's lack of sufficient views. Like for three-dimensional design, you should submit 6 orthographic views to make sure the examiners understand your three-dimensional design well enough at the time of filing internationally. If you fail to do so, it could be a little bit tricky to overcome it. So we suggest you to already file sufficient views when you file the international design, if you consider China as part of the contracting party of your international design. And the last one is enforcement. And for the enforcement, it's related to the registration certificate. So the CNIPA in China, even though your international design has been granted, but you will not receive the registration certificate in Chinese. you will receive a statement of protection, which is not in Chinese. Why? I mentioned about the language, because in China, if you want to enforce your rights, you need to provide the proof in Chinese, because a lot of authorities, including law and the police and the customs, they will not recognize the certificate if it's not in Chinese, okay? So to overcome that language situation, you should apply for a duplicate certificate of patent registration after your international design is granted. You can apply for it with the CNIPA, and you will expect to spend €4 to get this registration. But if you don't have the Chinese employee or Chinese entity, and you don't want to do it on your own, you can always hire a patent attorney to do it. Then you will expect to pay the lawyer's fees. That will not be more than €4. And the duplicate certificate is a must. You need to do it after you get the international design granted in China. And another one you can consider is the patent evaluation report. I mentioned that design will not go through the substantive examination. So to prove your industrial design is stable, it can be enforced, you should also consider to apply for patent evaluation report. This is very important when you actually want to enforce your rights, especially in e-commerce platform. And again, this can be applied with the CNIPA, and the official fees is around €300. And I already mentioned about the exemption of novelty. That means if you disclose your invention in certain situation, you can still you can still have the rights. You still have the right to register within 6 months. And the new rules extend the exemption of novelty in one situation, in the conference situation. So in the past, if the conference if in the certain conference which is recognized by the State Council or the National Department or the Chinese Academic Authority, in this situation, it could be satisfied the exemption of novelty. That is the past rule. And the new rule extends the situation of the conference by recognizing the conference organized and convened by international organization. And in that case, you can still, the invention still qualify for patenting within 6 months. Why this rule is important? This rule is favorable for SEP's owner. And as you know, SEPs are the patent, are the inventions, are the patents to protect those inventions which is necessary to implement in the standard, the implementing a particular technology standard. And for those SEP proposals which is submitted in certain conference, including 3GPP and ETSI, and also IEEE, those conference organized and convened by this organization, international organization, it's still possible to file your patent application within 6 months without losing the novelty. And I already explained those consideration and strategy before the registration. And we also need to consider what you should pay attention to after the registration. The first part I want to cover is the inventor employees rewards. The new rules actually make it more clear that the patent owner, in this case, it's the employer, they should cover the invention employee remuneration to satisfy certain criteria. For example, if the employer does not have the agreement with the employee, the minimum inventor rewards has been raised from 3,000 RMB to 4,000 RMB for an invention patent. And for design utility models also has been raised from 1,000 to 1,500. And these new rules has been into force since earlier this year. So if you do not have the employee agreement, you should check it. And again, without an agreement, reasonable inventor remuneration and awards are to be given to the inventor after you commercialized your invention. That includes either 50% of the net income from assignment or license of patent as rewards, or for independent or collaborative implementation of patent, 5% of business profits for 3 to 5 years as rewards. As you can see, those rewards are considerable for companies. So you should negotiate with your employees proactively about the inventor, about the rewards, and include the inventor remuneration in the agreement you have with your employee to avoid possible disputes. And also, open license system is available in China a couple years ago. What does open license mean? That means as patent owner, you can voluntarily license to any entity, any individual in China, and as an exchange, you can ask the CNIPA to reduce your annual fees of your patent. It's applicable to all types of patents, including the invention patent, utility models, and industrial design. But you need to wait for your patent is granted and published to ask for the open license. And you have to make sure your patent is valid. And patent evaluation report for utility models and design patents are required when you ask for open license system. So how to apply for it? You need to apply with the CNIPA again. You basically submit this patent open licensing declaration with them. And you can do it on your own. You can go through the online patent management system, or you can hire an IP agent to do that for you. And after the examination, this open license will be published on the CNIPA website, publication website, and everyone can read about your patent information and your willingness to open license to them. And in terms of the fees, you can choose either the flat fees or the royalty. If you choose the flat fee, it should be no more than RMB 20 million. If you choose the royalty, it should be no more than 20% of the net sales or 40% of the profits. And it's actually quite interesting because from what we observe, a lot of open license choose to be licensed freely. That means everyone can use their patent without paying anything. I didn't encourage all the European SMEs to choose that, but it's interesting observation. And as exchange, your annuity fees can be reduced by 15%. It's actually quite a low percentage. It's not fully reduction, but only certain amount of reduction. And if the CNIPA realize this open license is filed out of bad faith, or the patent itself is bad faith, it should be invalidated, then the CNIPA may put a fine of up to 100,000 RMB to the patent owner. And I mentioned many times about patent evaluation reports. And there are some new rules as a industrial design owner or utility model owners you should pay attention to. So the patent evaluation report, they are very important for those two certain patents, not including invention patent, especially in e-commerce platforms. And the new patent rules states that patentee and accused infringer can apply for patent evaluation reports. And also, furthermore, if any parties agree with the results of the report, they can ask for a correction application. So the reports will give a positive or negative result regarding the statutes and the stability of the, let's say, industrial design, which is an example. And what does the accused infringer means? That includes like the defendants in procedures at the courts, and the receipt of a warning letter, and also the response of an infringement complaint filed with the e-commerce platform. So for EU SMEs, you can either be the patentee, you can also be the accused infringer, especially in the e-commerce platforms. What's our suggestion for you? If you are the rights owner, you want the report result positive for you. So in this case, you should file the PR as soon as possible, because you can also file the correction earlier as possible to make the result as you wish. And if you identify any infringement in the e-commerce platform, you should request the PR before you even file the complaint in the platform. And if you unfortunately receive a complaint from other parties in e-commerce platform, that means they suspect you as an infringement in the e-commerce platform, you should also request a PR of others' patents. In this situation, not your patent, and you want to make the patent result as negative. And if the result is not what you want, again, you can request correction to make sure the results and to challenge the results. And I know it's a bit complicated, and here it's just an example of patent evaluation and why is it important for e-commerce platform. This is a real case we encountered in the Helpdesk. There's a Belgian company in the medical device industry. They have invented in the dental instruments, and they actually protected as industrial design patent in China. And the challenge they have is they found infringing products on a major Chinese e-commerce platform. So they want to remove this infringing product from the platform. And they contact the platform to ask if they can remove this platform. The SME actually already filed the patent registration certificates, and they thought that would be enough to finish the complaint, but it's not. The platform still asks for the patent evaluation report because to finish the complaint, the registration certificate alone will not suffice. You still need a report. And the SME followed that, and it took the SME 2.5 months to obtain the evaluation report. And that means the whole procedure to remove that link is delayed for 2.5 months, and the infringer has the opportunity to sell on the e-commerce platform for 2.5 months. Finally, after obtaining the report, the e-commerce platform accepts the complaint and remove the link. From this case, you can see after the grant of the industrial design patent, you should also apply for the patent evaluation report as soon as possible, because you will be required to submit that in the enforcement proceeding, like the removing infringer link from e-commerce platform. And the last strategy is about the invalidation of bad-faith patents. And this is the new grounds for invalidation. If you encounter bad-faith patents, which include the unnecessary restrictive patents, for this patent application, it should list massive amounts of details, but they are not really provide any technical solution. For that kind of patent, you can conclude it as bad-faith patent. And also for the fabricated or plagiarized invention, for this patent altering technical solution of prior arts and stating those technical effects which can never ever be achieved. Those patents also bad-faith patents. And for European SMEs as a patentee, it's a good news that you can invalidate other bad-faith patents. But don't forget that you also face the risk that your patent will be challenged by the third party on the very similar grounds. So we recommend you to prepare beforehand. What to prepare? You should preserve the relevant documentation and records showing that the creation and the development proceedings of your invention, making sure when others challenge its bad faith or copy of the prior arts, you have the proof and evidence to defend yourself. Lastly, some takeaway messages. So first, IP laws and rules develop greatly in China. Keep yourself updated. And there are 3 types of patents in China. Carefully scan your technology, your invention, and choose to register the suitable ones. And international design is available in China, yet the requirements in China is different from other countries. So make sure you understand, you are aware of that, and talk with patent attorney when you decide to extend your international design to China. After patents register, proactively take actions and avoid compliance risk. And you should consult with the IP lawyers and experts. You can always contact us if you have any questions. This is the channel you can find us, China IP SME Helpdesk. Thank you. Have a good day or have a good night.